Everyone, everyone okay? Everyone seated? All right, there are still some seats here in the front row. So finally, welcome to the panel that is dedicated to the stuff that you haven't heard so much about previously, which is the enforcement in the public sector. So there won't be so much talk about the one-stop shop and the consistency mechanism and dispute resolution. This is, as Monty Python would say, something completely different. I'm your very local host because I live here in Saint-Gilles, just across on the other side of the Midi railway station. My name is Juraj Sajfert. I also moderate this panel. I work at Vrije Universiteit Brussel, and I do a PhD there in a research project where we look at different, what we call digital investigative measures in in criminal proceedings and criminal investigations, and we try to see whether we try to measure whether they are compatible or not with fundamental rights requirements. So in that context, we were looking at the enforcement, or better to say, absence of enforcement against the law enforcement authorities throughout the EU. But here we will speak about much more broader topic, not only about law enforcement, but public sector in general. I thank you for your patience, especially the ones who were not in the main auditorium. I apologize for the delay. We'll still take 1 hour for the panel, so we'll wrap it up around 11:15, and we will leave enough time for questions from you, the audience. But without further ado, I would like to start introducing our speakers, who will open the panel with their introductory remarks. We have, as you can see, a great lineup of speakers, so people who really, try to get this enforcement in the public sector done on everyday level, on the ground, on the practical level. I'm the only academic here, and are surrounded by people who actually do it every day. The first speaker today, it's a great privilege to have you here, because the first speaker today is Saskia Rickmon. She's a member of the European Parliament since 2019. She comes from Belgium and is part of the Greens EFA group in the Parliament. Saskia, you work in the LIBE Committee, in the Pegasus Inquiry Committee and International Trade Committee. And in the LIBE Committee, in particular, you are looking at police, judicial cooperation, and migration matters. So you were also part of the Europol reform, the founding act of Europol reform. You look at police cooperation and justice cooperation on the international level as well, migration databases like Eurodac. So my first question for you to start the discussion is, because this is sort of fresh out of the oven, the reform of the Europol regulation. How did you see that from your standpoint, and especially when it comes to the focus of the panel, how did you see the developments in both administrative supervision by the Data Protection Supervisory Authority, which in this case is the EDPS, and political supervision, which is also something maybe tailor-made for Europol? So the floor is yours.
Thank you. Thank you. Am I on? Yes. Thank you. Good morning, everybody. And let me first thank you and thank the EDPS and the whole team for inviting me to discuss on this important topic this morning with you, knowing that the issue of the enforcement of data protection rights in the public sector is of course key and many times overlooked. So this conversation is very, very important in that context. As you mentioned, I've been working the last 18 months on the reform of Europol, which is the police cooperation agency at the EU level. And the issues of enforcement and supervision were and still are key, but also very problematic in the frame of this reform. So let me maybe give you some insights of the negotiations that have been going on and the context of this reform. So back in October 2020, the EDPS, that you know very well, launched an admonishment procedure against Europol for analyzing large amounts of personal data outside its legal framework, meaning data not related to ongoing investigations. A little bit later, but not that much, in December 2020, the European Commission came with a new proposal, basically legalizing Europol's wrongdoings. And this is how it started, how this reform started and was presented to us, as the European Parliament, starting with the LIBE committee, so the Committee on Civil Liberties, Justice and Home Affairs, also dealing with fundamental rights, of course. So the European Parliament and also the LIBE committee, unfortunately, with very few expectations, warmly welcomed the proposal from the European Commission. And why is that? How to explain that? I attribute it to the fact that it was mainly presented as a technical reform to MEPs. And so very few MEPs actually really digged into it from the very beginning and didn't see or want to see the problems after this reform. So the Council, member states, also broadly supported the proposal. And I have to say, through the whole negotiation process, Europol was really present and also lobbied the MEPs in order to make this reform pass as the European Commission was proposing it. 2 years later, so in January 2022, the EDPS issued an order to Europol to delete the data stored outside of the mandate. And I have to say, in the middle of the negotiations, that this was a very brave move from the EDPS. And in my view, in the view of my group, very right thing to do. Although the order itself gave some flexibility to Europol to delete the data. So it was not a radical order, just demand to comply with the law. The Council under the French presidency quickly drew a new article, Article 74 new, for the ones that are interested. And to make a long story short, basically, this article was just circumventing the EDPS order. So I was almost the only one as a shadow MEP for my group to contest this way of working and this approach. Anyway, the trilogue, so the negotiations between the Parliament, the Council, and with the Commission were concluded on the 1st February 2022. And in May, the adoption of Europol reform was concluded with a very broad majority. Of course, not the votes of the Greens, neither the votes of the left. And with very fundamental rights issues at stake. So the end of the story, what is it? So what is inside this reform and what made us contest it? Well, Europol is now able to process very large amounts of complex data. Their words, not mine. The big data challenge is met with this reform. And of course, data, as I said before, not related to a specific investigation. Data also coming largely from the member states. In addition, exchange of those data with third countries, with international organizations such as Interpol. Currently, there's also a negotiation going on between the EU and Interpol for improving and amplifying data exchange. Third countries, international organizations, but also private companies will be facilitated through this new reform. And last but not least, research and innovation capacities of the agency are also developed. Machine learning tools will have all those data at disposal to be trained. So it gives you an insight on the new competencies of Europol. And taking back words that have been mentioned many times, did we just at EU level allow Europol to become the 2000 NSA-like of law enforcement agency? Well, I'm afraid to say yes. a very broad majority decided to do so. So, is everything dark and negative? I hope not. I hope we'll be able to move forwards and to ensure data protection is enforced in that context. And of course, we very much rely on the EDPS to do so. It's a very precious ally for the ones that fight for fundamental rights and specifically data protection. Because without their action from the beginning, we would never have known about the problem and the processing of such large amounts of data by the agency. So these wrongdoings wouldn't be known. Of course, it led to a reform that is legalizing these wrongdoings, but still it is precious to our lawmakers' work to have the EDPS controlling, supervising the work of the EU agencies, and particularly here in this example of Europol. The example of Europol is far from being an isolated one. And the amount of files with data protection implications are ever growing. So I have to say, from the beginning of my mandate back in 2019, many files, and not only in the LIBE committee, are dealing with issues related to data protection, which means that the work and the workload of the EDPS and teams is also ever growing. So what we need to do now is also to allow the adequate financial and human resources to make EDP's role grow with the growing amount of work. Along with the EDPS, the previous reform of the agency introduced a joint parliamentary scrutiny group, so a group with MEPs from the European Parliament and with national members of the parliaments, which are supposed to scrutinize Europol's work. Why do I say supposed? Because, well, currently, and from my short experience, I can already see and experience that the meetings of this joint parliamentary scrutiny group are meant to be a showcase for the Commission, for Europol, also for the presidency in place of the Council, to set on the agenda the elements they want to show, and so which realizations they've been doing. I'm maybe a bit cynical, but I, through this joint parliamentary scrutiny group, can not really scrutinize the work of the agency. The agency is free to provide us with answers during the meetings or to written questions, but without really having, consequent answers. There's no automatic right to access the documents. There's no investigative power of this group, so it's quite problematic. So one of the fights I will be leading in the coming years will be to improve and to try to influence the agenda setting of this joint parliamentary scrutiny group. We obtained to have an observatory member in the Europol's management board from the scrutiny group. So step by step, there are challenges ahead, but we'll still try to transform the GPSG into a real scrutiny group and to gain independent supervisory power over the agency. This was something I already asked during the reform, an independent supervision, which we didn't get. No group was supportive to have an independent supervision of the agency. Of course, the EDPS is already scrutinizing Europol's work on data protection, but the implications also when it comes to using artificial intelligence and so on are also important on fundamental rights more broadly. And so I think we need a proper supervision on the respect of fundamental rights by the agency. I will not I will end by giving a second example, but without entering into the details, I assure you. It's the inquiry committee you mentioned. I'm coordinator for the Greens in the inquiry committee on Pegasus. So if we meet again, I'll be able to tell you about our inquiry work, because, you know, Pegasus, spying software that has been used also illegally by some member states, by third countries, to spy on individuals, lawyers, journalists, human rights activists, without their knowing. Very intrusive spyware that's put on your cell phone without even noticing, and which poses huge issues in terms of fundamental rights, and particularly data protection and right to privacy. So this is another example where public authorities should and do not respect data protection. Thank you.
Thank you very much, Saskia, for well, painting the picture in an honest way. And the picture is what it is, even if it looks a bit depressing. But I think the public has the right to know whether the supervision is being circumvented or not, whether supervision is being window dressing or it's actual supervision. So thank you for being so honest with the public so that they know what's happening. I will now transition to our second speaker, which is also an opportunity for, if some people are still standing up or squatting over there, you can move to the other side of the room because there are empty chairs here. So our second speaker is Alyna Smith. You are the Deputy Director of PICUM, which is a platform for international cooperation on undocumented migrants, which is a network of 164 organizations in 30 countries. And Saskia was speaking in length about the example of Europol, but I think there are, especially in this area of police cooperation and migration, which is your topic, there are a lot of weird legislative developments, and one of them is also a topic that maybe not so, that the public is not so familiar with, which is the interoperability regulations. So how do you analyze the deployment of interoperability of EU large-scale databases, both migration and police cooperation databases, and its effect on people who are in those databases, which are third country nationals predominantly, and the supervision of that data, especially data protection supervision in that context.
Thanks very much, Juraj. And indeed, what I'm going to reflect on is some data protection challenges, I think to put it mildly, in the migration context. And maybe just to start with the maybe obvious point that the GDPR applies to all data subjects. So it's not limited in terms of a person being an EU citizen or even having a particular resident status. It's applicable to all data subjects. And yet what we see is actually the development 1 year after the enactment of the GDPR of the adoption of these interoperability regulations. So what are these interoperability regulations? So these are regulations that essentially provide a legal basis for creating a kind of interconnected set of databases with the purpose of increasing the ability to address irregular migration and serious crimes like terrorism. And so what we have is a baseline of 6 databases, some of which were pre-existing and some of which are yet to be implemented, and then foreseen an additional layer of information technology architecture that would allow then for these to be interoperable and for these to be searchable by various authorities. And so again, some of these databases were pre-existing. So for example, like the Eurodac system, which is a system that has the information or the personal data of people in asylum procedures. We already had the visa information system with the personal data of people applying for visas to enter the Schengen area. We already had the Schengen information system, which is a law enforcement database. So we had a number of these systems already. So I just want to share with you some language from a European Commission paper on information management in the area of freedom, security, and justice from 2010. A single overarching EU information system with multiple purposes would deliver the highest degree of information sharing. But creating such systems would constitute a gross and illegitimate restriction of individuals' right to privacy and data protection and pose huge challenges in terms of development and operation. And yet 9 years later, here we are. Well, there we were. With precisely the centralization of these databases for the purposes of law enforcement and immigration enforcement. So the whole interoperability framework we can see is already problematic from a privacy and data protection perspective, even as recognized by the European Commission itself almost a decade before. But I think it's also really important to understand that there are profound concerns about the repurposing of data that's essentially built in to the system. So repurposing of data intended primarily for the context of asylum applications, now explicitly linking with criminal justice purposes, linking quite literally with the ECRIS TCN, which is a database of third country nationals with criminal records, with the Schengen Information System, which is a law enforcement database. So there were concerns about data minimization, there are concerns about repurposing, there are profound concerns on that level, but there are also, I think, important concerns that we need to understand by stepping back in terms of the purpose and design of the system in the first place. And so the central information repository, that one of the new systems to be developed that would allow for all of this interoperable operation, foresees a capacity of 300 million records. So we're speaking of essentially the personal data of virtually every third country national with any administrative ties to the EU. So why? Why this enormous, this colossal system, enormously resource intensive? Well, for immigration enforcement and criminal justice purposes. And so again, I think we need to really query the very premise of the creation of a database that essentially exists because of a conflation between being a third country national, being a non-EU citizen, and being a risk of terrorism or high security risk. So I think that is already something we need to be querying and concerned about in terms of broader fundamental rights concerns linked to the creation of this database. And so one of the key aims of this interoperability project, so yes, it's an EU framework, but is to create or to establish a basis for a vast centralized pool of identity data that makes it easier for officials at the national level, so border authorities and police authorities, to essentially identify people on the territory who would or who would enter the territory. So essentially, to bring efficiencies to stopping people for ID checks and deportations. So again, we can see that there are very important consequences at the national level. And one of those consequences has to do with interactions with law enforcement authorities, where there's, again, already a broader context of how stop and searches already happen with certain groups. So maybe just a point about enforcement, maybe some general points from the perspective, again, of undocumented people, of migrants, the people who are essentially the subjects of these systems. So again, maybe you have an idea. We're talking about an enormous system, sets of systems that are now to be interconnected. And so we have enormous complexity. And so that complexity itself presents an enormous challenge for accountability. So how do we understand responsibility? So if there's erroneous data, incorrect personal data on those systems, how do we understand who's responsible for that, what the processes are to rectify that, and potentially to remedy harms that can result? Because there will be decisions made on the basis of information in those systems, including decisions about who to apprehend, who to bring to the police station, who potentially to detain and deport. There's obviously an enormous power imbalance between the data subjects and the authorities that are gathering this data. So how do we even understand notions of consent, notions of notice? How do we, I think we really need to grapple also with those dimensions of the issue as well. And we're speaking about the processing of data in a way that's highly opaque and very, very hard to even get insight on. And then I think it's important to also understand what we have in terms of ambiguities, in terms of the applicable legal framework. So we have the GDPR, but we also have the Law Enforcement Directive. And we essentially have a commingling of purposes within this system. And I think important ambiguities about which system should apply. Again, because applying for a visa to come to the EU, applying for protection, there's no immediately obvious sense in which these are criminal justice matters, but we're now in a system where all of this is commingled. Briefly on the future, so we've already heard, we have these systems in place, but we are already in a context of the increasing use of automated decision-making and artificial intelligence. And we already know that some of these underlying systems foresee precisely the use of those technologies to do risk assessments and various other things based on screening rules to identify who is fitting certain categories of risk. And we have the AI Act now, where Article 83 of the existing Act foresees the exclusion of these databases from the applicability of the EU's regulations on artificial intelligence. So I think it's really important to understand, again, of course, there's going to be an appetite and a sense of the need to use these types of technologies because of the enormity of the amount of data we have. But then what is the adequacy of the regulations we have to really have oversight over that, to even understand what accountability means in practice for people who are affected, in particular in a context where the relationships between those gathering the data and those whose data is concerned are already where there's a context of inequality and it's quite fraught. So maybe I'll leave it at that for now. Thanks.
Thank you. Thank you very much, Alyna, for demonstrating to us how difficult it will be to supervise data protection, ensure data protection supervision in the context of interoperability and these large-scale databases. So we spoke about the law enforcement, we spoke about migration, and now we will transition, and mostly in the EU context, we will transition to other areas because public sector is a lot of other things as well, and more also in the national context, not only in the EU context, and that's why I'm very happy that Evelyn Austin is with us. She's an executive director of Bits of Freedom, which is a Dutch digital rights organization that for 2 decades have been working on shaping the internet policy in support of open and just society in which people can hold power accountable. And Bits of Freedom does that work through advocacy, through litigation, through campaigning in the Netherlands and also here in Brussels. So I think everyone knows in the room about the social benefit scandal, let's call it like that, with profiling for social benefit in the Netherlands. So we don't need to dwell so much about what actually happened, but for us it would be interesting to know how did you perceive the reactions afterwards, and what actually happened after the scandal was made public, and whether the Dutch Data Protection Authority has actually done something in order to remedy what happened.
Yes. Thank you. I'll try to answer that. I think every Dutch person working in a rights organization has become this representative of this child benefit scandal when going abroad, which feels kind of odd. But I guess that's just the reality where we're in. So I won't go into the details, as Juraj said, of the scandal itself. I did think it would be interesting to just go through a brief timeline of events because it's not as clear-cut as it became known and then the DPA acted. So the new child care benefit scheme was introduced in 2005, sort of to the background of increased appetite to detect fraud. In 2013, an algorithmic decision-making system was adopted, which was called the risk classification model. And that was when many families started having their benefits withdrawn. So they weren't only withdrawn, but they were told, it is very likely that you've been defrauding the system, and you also have to, not only will you stop getting the benefits that you were, but you also have to repay the ones you've received, often for years and years. So people were met immediately with huge debt. And because they were defined as being fraudulent, they also did not have the right to sort of debt repayment schemes that you usually would. So in 2016, the National Ombudsman issued a report saying, I think something isn't going well. In 2018, a few members of parliament started asking questions. In 2019, those questions started being answered very, very slowly. And the information started sort of trickling in. And finally, in 2021, the Dutch cabinet fell over this. The DPA's timeline for their involvement is something that wasn't actually known at the time, but became known kind of towards the end of all of this. But it turned out that the Dutch DPA had received a signal, we're not sure what that means, but a signal that nationality might be playing a part in how the tax service was treating people. So that was 2017. So they reached out to the tax service then. We also don't exactly know what that means. In 2019, and then again in 2020, the DPA paid a working visit to the offices. And then not long after that, they issued a report stating that the tax services was operating contrary to the law. And then in 2021, it announced that it was issuing a fine, almost 3 million euros. And they also spoke briefly then about what this process had been like for them. What is interesting is that they mentioned that the tax services had obstructed their investigation, and that's one of the reasons it took so long. And this is also against the backdrop that the tax service already in 2018 said, GDPR, we're not going to be able to comply with that, maybe in a year's time. And then in 2019, they said, yeah, we still aren't compliant, and they didn't give a deadline for when they would be able to become compliant. And then finally, I think last year, they said it will be 2024 at the earliest. So what I think, so there are a few interesting things. I think this shows us something about what we can be expecting from sort of data-driven administration. And then it also tells us something about what we can expect from enforcement by the DPA. So to look at the first point very quickly, one of the I thought most painful aspects of the tax services work was that it was based on what they called the 80-20 approach, or a group-based approach. So the 80, this is something they made up, it's not based in anything factual, but they said if you take any given group, 80% of people will be, 20% of people will be innocent and 80% of people will be guilty, and that's a risk we're willing to take. So it really reminded me of this concept of the edge case in computer programming, I guess also because they were using this algorithm. But an edge case in computer programming is you design your system to work for as many people as possible, and you try to make the situations or the people it won't work for as small as possible. Interesting. But 20%, of course, is a wildly high number. Like 1% would be acceptable, maybe. But 20%. And I think a big part of why that was acceptable for the tax service was because the groups they were looking at were people of color and people of a low income, so they could just simply get away with it. But if we take that 20% and look at the number of people in the Netherlands that receive childcare benefits, it's 583,000 families that obtain childcare benefits. So 20% of that would be more than 100,000 people, families. The tax administration was also fined last year for this extensive fraud list that they were compiling. 20% of the people on that list was 50,000 people. So just these two systems alone, we have nearly a little over 150,000 people who the tax services say, we know you're innocent and we don't care. So when we transpose this to the trend of sort of data-driven administration, we see more and more people that are going to become a victim of this. We also see a DPA that is not particularly capable of assessing the kind of broader human rights implications of data protection issues. The DPA has and does until this day deny that the profiling that took place was racially motivated, which Amnesty International, that did a really, really good report looking into the system, says that's just, it's nonsense. It is definitely racially motivated. The Ombudsman, also partly based on events over the past couple of years, has said they described the DPA's approach to complaints handling as deflective. So rather than supporting people in filing complaints and supporting them through the process, they try to discourage complaints from being filed. And that's also Bits of Freedom's experience. Another thing we see is, so the DPA said itself that the tax services obstructed their investigation. I think if they're willing to go that far, it was probably a lot worse, and the wording we would use for that would probably be a lot stronger. But let's stick with the sort of politically correct. We also see that the DPA in 2021, in 95 occasions, issued a recommendation on legislative proposals that the government had made. And in 20 cases, so in 20% of those cases, the DPA said this is so bad. It's basically a free-for-all for unlimited data collection and sharing. Huge changes need to be made, or maybe it would be better to withdraw the proposal. And they don't get listened to. So we have more citizens being harmed. We have those harms falling on the most vulnerable. Rights aren't equally protected. Rights aren't equally distributed. The trust in institutions is going to become even lower. And I think with the DPA not acting as people would like them to, it's also very likely that people and rights organizations will start bypassing them altogether and move to legal action immediately, which I think also will exacerbate some of the inequalities that we already see. Sorry for your timekeeping.
No, don't worry about it. Don't worry about it, Evelyn. It was very, very interesting. And for me, after these three interventions, my simple question to my simple mind is like, okay, does public sector really have to be worried about data protection supervision, or they just do their thing and don't care about it? And who better than to address now than Fanny Coudert, who is actually working in the European Data Protection Supervisor since 5 years and is a head of sector for supervision of the area of freedom, security, and justice. So in that context, in that sort of bleak picture that is now being painted in my brain, my question is whether, for you, whether we can actually improve because we have a lot of issues here that are actually EU-wide issues that are repetitive in a number of member states, or that are actually created by some cooperation between the European level, national level, or member states, national authorities working together. So my question is whether we can improve the cross-border cooperation of the supervisors of the public sector outside of these mechanisms that were created for the commercial sector, like the one-stop shop or consistency mechanism. And also even outside of the GDPR, if the matter is outside of the scope of the GDPR. So the floor is yours.
Yeah, I think this intervention shows that it's really as important to supervise the public sector as it is to supervise the private sector, which is the topic of this conference. Because of the, I mean, we've shown that the public sector is collecting each time more and more data, and the impact on citizen, on individual is huge in the field of law enforcement, migration, or even social benefits. I mean, there's an impact on the right to fair trial. This is exposing people to deprivation of liberty, denial of entry to the EU territory or access to social services. And we see with the recent reforms or the Europol regulation or the development of the interoperability framework that there is a trend to increase even more this the amount of data being collected. To develop this structural cross-border exchange of personal data between national authorities. But also, when we think about agencies such as Europol or Frontex, or Juraj or EPO, this is also developing a structural data exchange between the EU level and national authorities. So we are creating this kind of spider web, which is just magnifying, I would say, the issues we are discussing right now, because if there is a risk already at national level, well, data starts flowing all over Europe and being exchanged between many different national authorities in 27 member states. This is creating a high risk for individual. Because the risk they are being caught in this spider web, and it's very difficult to get out of it. It's extremely opaque. It's already opaque national level, but then when it starts flowing and we're building this huge database, it's become even opaque. It's not clear who is processing what data for which purposes. So this call as well for cross-border enforcement in the public sector as well. I mean, the reform of GDPR were more targeting the private sector because there was obvious need for developing cross-border enforcement. But I think now we can also see there's this need of cross-border enforcement in the public sector. And what does this mean? It means that we have to think about how to make the exercise of the right of individual more effective. Because we are creating all this database and this structural exchange. We're trying to think into introducing some data protection safeguard, but what we are not thinking about is how can we have effective rights in this, do we need specific mechanism, and how can we have effective supervision as well? How should data protection authority work together? So just to, I mean, in this interoperability framework, we have individuals who have to file multiple access requests to authorities located either at national level, at EU level. We have already received complaints from individuals being stopped internally at the border, and we didn't know why, in which database, why they were being stopped, because, I mean, they were not so. What did they have to do? They have to file a data subject access request to Europol to know, am I in the Europol database, to SIS, to all these different systems, to all these national authorities. And the problem is that for us, for instance, when it reached the EDPS, we're only competent to supervise Europol. So it's because we got an answer from Europol saying, no, you're not in our database, or you're not entitled to get access to. So, and we can only look at that. But then they have to do the same thing again and again for all the other database. So we have to, I mean, that's something we have to think, how do we want to, maybe not using one-stop shop, but a single contact point, so, and then to facilitate this kind of access. And this means as well that Data Protection Authority will have to cooperate closely in the instruction of complaints, but also in conducting joint supervisory action, just as joint investigation, and because in order to be able to track where the data is going and to check at all levels. Because when data flows between different authorities, which are subject to supervision of different supervisory authorities, if we want the supervision to be effective, a supervisory authority needs to act together, and that's something we have seen, for instance, in the context of the supervision of Europol, because I mean, national law enforcement authorities share data with Europol, but if we supervise only at EU level, we're missing part of the story, actually. This has been the case, for instance, for we looked at the processing of data about minor or below 15, which were labeled as suspect in the Europol database. I mean, this information comes from a member state, so we can check at EU level, but if we don't get the cooperation from national level, we will check whether the national authority, the police authority, share this information in compliance. Could they, this minor, be labeled as a suspect and why they are under 15? So we really, so we need to have to look at the whole data flow to be able to have an effective supervision, and this will become even more necessary, I would say, with the request of the Europol reform, because I mean this now Europe also can process this large data set, so we are talking about a huge data set. You could think about EncroChat, which are millions and millions of messages being exchanged and shared. And the safeguards in the request mainly rely on national safeguards. Basically say, well, if it has been collected lawfully at member state level, if they respect all the safeguards from the national criminal procedure, then that's okay, this can be shared with Europol. And so if we want to start looking at supervising these data sets, we will have to cooperate with national authority, who will have also to look at national level. So my point being, we really need to develop this cross-border enforcement in the public sector.
Fanny, thank you very much. I fully agree with what you said, but after the entire round, I'm super depressed because the DPAs are already drowning with the GDPR and the big tech, and how they can do more about the public sector. I don't have an answer to that, but maybe we'll get there in the remaining 20 minutes. I had a second round of questions, but I don't want to monopolize the entire panel with us speaking with each other. So I will actually open the floor to the audience at this point. You can raise your hand. The microphone, our colleague with the microphone is over there. Introduce yourself, ask the question. We have three people already raising their hands, I saw. Before we give the floor to the lady in the first row, I will just ask the panelists if they would like to briefly react to what they heard from each other. Yeah.
I think this is going to add to your depression, but I really identified with what Saskia said about, so both about kind of wrongdoings being made right with new legislation, so basically legalizing the fuck-ups, excuse my language, that these law enforcement agencies are doing. And then I think another thing you said was the big data challenge that's being met. I think a lot of investment goes into technological capabilities that allow us to collect and share and analyze more data, and not so much investment goes into protecting the human rights that come with having that data. So maybe one sort of solution could be sort of looking towards what incentives need to change for that to change, because otherwise I think we're just going to keep running into the same problems in every member state and at an EU level.
All right, Saskia?
Sure. Trying not to be too dark. But I think all the interventions show growing tendency in the name of security, combating fraud, combating criminality and terrorism, combating also child sexual abuse. It hasn't been mentioned in the panel, but it's also a very legitimate purposes, actually, but that allow for more and more violations of broad fundamental rights of large panels of citizens through what we call mass surveillance. And this is a growing tendency that doesn't go hand in hand with public debate. And we see that mainly, I think, from 2015 and the terrorist attacks, and this has been a growing trend, also relying on technologies to try to find quick and what they call effective solutions, without digging into those solutions to see whether they would impact fundamental rights And I see it in the debates we have. Many of my colleagues do not even care, of course, and know about the impacts, for instance, of using facial recognition and also the disproportionate impact of measures that you've all mentioned on vulnerable groups, be it migrants, be it minorities, that such measures have. So I think one of the steps, and it's what you do today, it's what I try to do also through my work and talking about it, it's to raise public awareness about our rights and that we need to fight for our rights, and also ask our representatives for accountability. Because I think as long as there will not be enough political will to enforce the role of DPA at national level, we'll face the same issues. Because, as you said, they're already dealing with a lot of issues. And you mentioned it in the Netherlands, it's the same in Belgium. I think the role of the DPA is not taken seriously. And there's no possibility for the DPA to enforce its recommendations or to have another way of acting towards governments if they do not comply with the recommendations. So enforcing their role at national level is also something that needs to be done.
Thank you, Saskia, very much. That's now we are in a more positive mood, so we can go to the floor. We take the first three questions from the floor. So Patricia first, the gentleman in the second row, and there was a gentleman in the fifth row.
I must say this is though depressing, very interesting, because it's like you're telling the story of my life.
Could you introduce yourself?
Oh, my name is Patricia, because you said Patricia.
Yeah, I see your name tag, but other people don't.
My name is Patricia Poku. I'm the Executive Director of the Ghana Data Protection Commission, the President of the Network of Data Protection Commissioners of Africa, and the co-chair with UK of all Commonwealth Data Protection Authorities. I have been doing data protection, obviously, for years, 15 years in the EU before I was appointed to go to Africa. So, and I worked in the public sector. So all these things you're saying, I'm very much aware of. And the reason why I find this very interesting is that now in Africa is when there's this wake up to the use of data, artificial intelligence, and what you're describing that has already happened in Europe. We are on the verge of wanting to do it, the verge of applying artificial intelligence, big data, and it's like a big excitement ahead with all the things that we can do with the data that is now all being digitized or have just been digitized. And leaders, political decision makers, people at key ultimate decision makers are just about launching themselves into these same positions that you are speaking about, creating data markets where data can be easily exchanged and analyzed and aggregated to make decisions about people. But the worst of it is that here, data has even been collected properly. Whereas over there, because of the lack of data protection awareness or not enough laws being enacted, it's even riskier how the data is going to be used. And worse still, we got to the point how individuals can assert themselves. My question to you, just for my own thinking, because I'm often consulted to kind of support the decision, and you will be in that position as a supervisory authority where key decision makers always want you to support what they're doing, and you're saying that they want it to feel right, knowing full well that this combination is very risky. They almost push you to support it, to say that it's okay to do, knowing that the decisions coming out is just going to impact beyond individuals to communities. So my question to you is, what do you see as the way out of all of this? What do you suggest the European supervisor should do?
Okay, thank you. That's $1 million question. You can pass the mic to the gentleman in the back. Yeah.
Yes, hello. Thank you very much. Very inspiring and a little bit depressing, but I knew quite a bit of that already. My name is Wilmar Hendricks. I'm on the board of another Dutch NGO, which is Privacy First. And also on the chair of the board of Quick, a new foundation which we managed together with NOIP to go to court on behalf of consumers. But that being said, that's my CV, not very interesting, but the important question is, what do you think about alternative punishment for public sector? Because the very strange thing is that the 3 million euros being paid by the Dutch tax department are being paid by Dutch taxpayers. And even the victims of the people that made the wrong decisions get repaid their damage partly, being paid by Dutch taxpayers as well. Not €1 is being paid by the guys and girls that did it wrong. So, would there be an alternative for that? For example, what do you think about, and that's my question, leave it to that, no politic positions anymore, no public positions anymore, never work with personal data again in their life in the European Union?
All right, and let's take the third question. You will be in the next round, yes.
Yeah, Hernani Sherazaro, Europe Data Protection Office at MasterCard. So, if possible, I'd like to bring another piece to the puzzle, which is the role of the private sector in all of this, right? Because it was a little bit missing. So, I think that there is a little bit of conflict of laws when it comes to access to data held by the private sector. And I guess that this is more for the European Parliament to respond. How do you see all of these access to B2G, G2B data in the context of data protection being solved in the presence of sometimes enforceable orders by the public sector to the private sector that are clearly conflicting with data protection law?
All right, thanks for the questions. Now let's hear some answers, and we'll have a second round of questions. I saw your hand. So anyone wants to reply to any of the questions? Anyone feels comfortable? Alyna, you want to start?
I'll take a stab at the first question, your question, Patricia. Maybe just, I mean, it's an enormous question, so it's just one little thought about that. So I think, you know, as we heard in some of the discussion here, I think there is excitement about technology, right? There's a sense in which, yes, innovation, you know, yes, solutions, yes, economic opportunity. And I think, you know, again, when we see the AI Act, that's the big push, is this is about economic development and innovation. Oh yeah, and fundamental rights. So I think we also heard about this kind of this notion again in the context of Europol's reform, that this was a technical issue, right? That this is technical, this is technology, and so we just need to have those technical discussions. This is about efficiency, right? This is about doing it better and faster. And I think what we heard is, where is the conversation about the impact? And who is in the conversations about the impact? So I think that's where civil society can be really important. So again, there's going to be an impact in terms of data protection rules and privacy rules, but then there's a human impact. And again, in the context of the interoperability regulations, I'm fairly certain there weren't a lot of migrant rights organizations that were part of any kind of consultation about impact. So, but there were lots of discussions, I'm sure, with private sector, security organizations, and law enforcement. So I think, you know, I think there needs to be a broadening of the conversation, not only about opportunity, innovation, and technology, but actually impact. And whose voice is taken into account, and the analysis then about the cost benefit. And very often it's not going to be about safeguards, but what we don't do, because the cost is too great. So I think there needs to be a recalibrating of the discussion about the role of technology and the risk of technology, and for whom. So I would just say that I think the role of civil society being very robust in the discussions from the outset about the what and the why are really important to the whole conversation before we even get to the implementation and enforcement. So yeah, just that little point there.
Thank you, Alyna. We only have a few minutes left, so Evelyn, do you have any thoughts on your colleague's suggestion or any, to find the people. Yeah, or another thing you want to talk about.
I would love to talk about that off the record. But what I could say on the record is what we see is that all these law enforcement agencies or public bodies are breaking the law, and the response is to expand their powers through new legislative proposals. So, I mean, to me as someone who hasn't given this much more thought than you, one easy solution to me seems, or not a solution, but one action could be stop expanding the powers. As long as the basics aren't being met, as long as enforcement agencies are breaking the law, don't give them additional powers.
Yeah. Simple as that. Saskia, do you agree?
Yeah, completely. I can't but agree more to what has been said by both of you. I think we completely need to rethink our relation to data, and we can improve ex ante, ex post controls. And I also think about the previous impact assessments. There is a huge gap of systematic impact assessment when there's a new regulation coming up. European Commission should be forced, should be obliged to issue an impact assessment first, including on data protection and fundamental rights. It hasn't been done in the reform of Europol. There wasn't a previous impact assessment done. So as lawmaker, we receive a new reform without knowing its impact on all the sectors, including fundamental rights. This is one problem, I think. The second thing is that even if there are very efficient ex ante, ex post control mechanisms, in the current situation and this challenge, this full excitement for more and more technologies and data gathering, I think we also need to rethink data collection and start again from the principles, for instance, data minimization. And this is not done either. So this is also something that we need to work on. Thirdly, I wanted to say, yes, sanctions towards public authorities. Well, yes. I think sanctions need to apply if public authorities do not comply with, but it's always a vicious circle because currently we're not even there about talking about sanctions. We're about who controls and is the control efficient. But definitely, I think like the private sector would be sanctioned if they do not comply with the rules the public authorities choose as well. I think there's a very good example in your country about an activist, Frank Verlinden, that has been considered as a terrorist, put on terrorist lists. And this is what you said previously. So his country's mayor put it on a terrorist list. He was on the list of Europol, of Interpol. And once the government decided to withdraw him from the terrorist list, his name was still on the Europol and Interpol list. So implications for fundamental rights are huge. There's no access to remedy. He opened many cases, many low cases, court cases, to access information, basically. He doesn't have access to, and access to remedy, and also who pays. And this needs to be also worked on. I think at EU level, we can work on the question of access to remedy too.
Okay, we have to wrap it up, but there was a lady who was very adamant about her question. So here in the second row, let's hear that as the last question and give a brief answer, and then we'll wrap it up.
I'm Alexandra Jasper. I'm the former director of the Belgian Data Protection Authority. And I wanted to just react on what Mrs. Bricmont said in her previous intervention. You said basically, and sorry if I summarize in just a few words, you said, well, it's up to the DPAs to make sure they enforce effectively misconducts made by the public authorities. It's absolutely true, of course, and no one can say the opposite. Just a reaction to this, I fully agree they should have more means, they should have more resource, both financial and in terms of manpower, of course, that's a certainty. Now, and I will tell you just what I've been living in Belgium. We have means, we have enough means, probably. The thing, there is no willingness. And why? How are the members of the Belgian DPA appointed, chosen? They are proposed by political parties. So they are all linked and committed, docile towards those political parties. And I don't have to draw anything. To the parliaments, the member of the governments, and hence to all the administrations. So why do we think that there will be some kind of willingness within the DPAs? I'm talking about the Belgian DPA because this is the only situation I know very well. Why would there be some kind of willingness to act against public institutions? Knowing also that in Belgium, the law is very clear. We cannot impose a monetary sanction towards a public institution. The only thing we can do, and we don't even do it, is a cease and desist order. Usually, what do we do in Belgium? We work with what we call, it's, in French, it's a blâme. We say, well, it's not good. We shouldn't have done that. You are bad guys. And on the left hand. So, well, I fully agree that authorities do need to have means and means to enforce effectively. But I think the first thing to do is for the Commission to act against the authorities who are not working independently and hence violating Articles 51 and 52 of the Gdpr. Sorry.
Thank you for the comment, and that is the end, the final thought on the of this panel. I didn't imagine it to be, but it was. Thanks everyone for being here with us today. It was a great discussion. Thank you very much to all four panelists, and obviously to EDPS for organizing this. Yes? There is an public announcement.
So Wojciech's keynote is delayed until 11:45, so you have half an hour for a coffee break. Yeah.
Yeah, enjoy your coffee break. Thank you.